We're here because Ms. posted on Facebook on a fateful summer day on Lake Tahoe. Ms. was in the water behind the boat. Ms. then instructs his teenage daughter to hit the throttle. The propeller ripped into Ms. body, causing significant damage. She is facing inevitable amputation surgery.
It's a divorce action style versus divorce action. We're here today for an order to show cause. Let's go ahead and take appearances.
Good morning, Your Honor. James Jimmerson, bar number 12599, on behalf of the plaintiff. He's also here on my right. And we have Patricia Erickson from our firm as well.
Good morning. Thank you guys for appearing. Mr. Ford.
Morning, Your Honor. Chris Ford, 11570, on behalf of my wife.
Good morning. All right, you go ahead and be seated. I've read through the documentation. I did issue the order to show cause based upon the request that was submitted by Mr. Ford's office. That was entered and filed on August 9th of 2024. It brings us here today. I had also conducted a hearing earlier in the week pertaining to media access by our judges. I apologize, Mr. Jimmerson. I directed you to prepare the order. When I got back, I realized an order had been submitted, so I tried to take the burden off you guys of doing that. So I went ahead and entered that order. Mr. Ford, are you ready to proceed today?
Yeah, I am, Judge.
Mr. Jimmerson?
Yes, Your Honor.
Okay, let's go ahead and get going.
All right, Judge. Well, I think the motion, as far as the contempt, kind of speaks for itself. There's admissions in their opposition that she did what we said she did, which is disseminate information. Now, when I read the opposition, they try to split hairs and say, well, nothing in there prohibits her from talking about things that were in this MSA. But the reality is, it says she can't, that there shouldn't be a dissemination of divorce proceedings or personal information. And I think those categories are really broad, right? And that's kind of what we came back to. Well, I think it is. I mean, I think when you talk about a divorce proceeding, we cited the case law in our brief. And in our brief, it talks about all the things that are kind of ancillary. It's not just the pleadings. It's not just the things that are filed. It's the things that have been raised in those pleadings. It's the things that have been subject to the filings. And here, the boat accident certainly was one of those terms, right? And so I think we have our hook there with respect to a breach and with respect to a violation of an order. And I think even if I'm giving some credence to some latitude to this idea that there's not a specific element or a specific prohibition, the problem I have is I think that determination would have to be made in an evidentiary hearing. I think we really have to get to the mind of these parties when they talk about what was in their mind relative to a divorce proceeding, what was in their mind relative to the term personal information, these confidentiality clauses. What was the basis for these? What were the things that were being considered? So we could use the law to inform us, which I think the law says it's very broad, divorce proceedings, and this is involved. Or we could use information that we would take from testimony from these parties relative to what was the meaning, what was supposed to be protected, what were their understandings. So I don't know that today they can defeat the motion on what I would say is a technical argument that the words, as far as a prohibition on speaking about certain items in the MSA aren't specifically enumerated in confidentiality clause. I think the court would have to give us some latitude and an evidentiary hearing still to show you that that was within the meaning of this agreement and then show that the violation occurred.
Well, let's talk about that for a second, because I looked at the paragraph. I actually broke the paragraph down.
Sure, me too, yeah.
Because I think when you're dealing with the contempt proceeding, you have to show, and I want you to listen so you understand.
It's fine.
You have to show a specific violation of a part of an order, okay? So what the MSA says, stipulated agreement, these divorce proceedings, number one, divorce proceedings, and any information regarding the party's finances, number two, party's finances, and personal information, number three, personal information, shall remain confidential to the parties and shall not be disclosed. Okay, so confidential, not disclosed. All right, so that's really the key words of that first sentence. The next sentence goes on. The parties further agree that any financial documents, number one, financial documents, number two, divorce pleadings. Okay, I'm putting the numbers on it. Okay, correspondence would be number three, and any documents for any documents related to the divorce shall not be disclosed. So on the one hand, I have 3 things that are confidential, subject to not being disclosed. The very next sentence provides 4 other things which I just enumerated, which are not to be disclosed. Okay? I understand your position. I think you recognize that I appreciate your position. That is why I entered the order that I did, requiring us to be here. I have read the opposition. By no means do I want to steal your thunder. Go ahead and make the representations that you
Judge,
did.
just one thing, I'm sorry, just one thing, because I did the same thing you did this morning. I literally numbered everything out, I went through that contract.
Great minds think alike.
Same process. And I kept coming back to, and I think this is why our brief honed in on it, the divorce proceedings. And so that's where, because I had the same question when we were preparing the reply. Well, do I get there? Is it specific enough? And I get the reticence on it from the court. But that's why we included the case law that talks about this very expansive definition, and that's from our own Nevada Supreme Court, relative to divorce proceedings. And so when they're talking about an expansive, the things related, the things included, I think I do have a specific violation, because it was included in the MSA, it was pled at hearings, it was argued at hearings. The boat accident was integral to that whole divorce proceeding, and it ended up being integral to the ending of it, vis-a-vis the MSA. And so that's where I'm having a hard time with the specificity issue the court's having, because I look at it and go, again, we have it under the broad description of a divorce proceeding. I think we have what we need to meet the contempt.
Well, answer me this, and I didn't want to put you on the spot, but I'm going to ask now.
Yep.
Okay. You apparently, in accordance with contact with your client, you reached out to her. Is that correct?
This is correct. We sent a letter.
Hold on. Let's take it one step at a time.
Yes.
And you said, hey, I'm paraphrasing, of course, we think you have violated the terms of the MSA. She responded, and she said, while I disagree with you, and I'm paraphrasing again, okay, but while I disagree with your interpretation of my having violated the terms of the SMA, I am going to go ahead and take off social media, whatever the account was, off social media what I posted. Is that how it went down?
Yes, and then she posted again via private messages, Judge, to different. And this is where it gets troubling, because it now goes to business affiliates. So at first it was the community at large that he lived in, and kind of like a Facebook post arena for that, right? And then it was family and friends with different messages. And then it goes to business associates. So now it's getting into his business and his ability to, and the problem I have with it is if you look at the MSA, he's supposed to pay her all this money pursuant to the MSA. I won't get into specifics, but he's supposed to pay her. Okay, if she's going to disseminate and badmouth and defame, or even if she's going to just give the reality of the situation, which was a very sensitive situation relative to this accident, how it occurred and how they resolved it, to different business associates. Additionally, Judge, the amounts, right? So my client's in the janitorial business. It's not something where you can go out into the community and let everyone know how much money you're making, how much money you have to pay an ex-wife, and then go around and sell your services to folks in DC that are looking for the best bargain for their commercial building to get clean. So it's gone beyond just maybe a petty Facebook post that got removed from our letter, and it's transitioning into further violations after the letter, and then violations that get into a business arena where my client's going to be affected, and it's going to affect his ability to pay. And the problem I have with it is she might turn around at a later date and say, well, he's not paying me the money he's supposed to. And when my client comes in and says, yeah, because my reputation has been diminished, because she's been spreading these things around, despite our confidentiality agreement, despite the fact that this was something that was integral to that agreement, that MSA, what's his defense, right? I mean,
Yeah, but aren't you talking about the motion that's before me right now?
Yeah.
I understand that could become an issue,
Yeah.
but I think that is a separate and distinct issue from that which is before me right now. What's before me right now is, do I have a sufficient basis to hold her in contempt for violating the specific content of the court's orders? Okay, that's the. I mean, I appreciate the argument. The way I see your argument going, hey, we negotiated something. okay? In return for the consideration that I offered as X, the consideration that she offered as Y, why should I be held for my consideration X when she hasn't complied with her consideration Y? But that's not what's before me right now.
Well, and really, that's not the heart of my argument, right? That's just, that to me is something that's kind of leads to where we are today and why we're here and why it's important that the court enforce this, because that's something that could happen down the road. That's something that's maybe ancillary to this or will be as related to how you decide this today. But I just come back to, again, you're asking me what did she violate? She wasn't supposed to talk about the divorce proceeding. To tell me the boat accident wasn't part of the divorce deceit, well, to me, how is it?
Let's stop for a second, because I appreciate this argument. Well, it's my understanding, and I haven't looked at it, it's a federal case, if I'm not mistaken. I haven't looked at any federal filings.
Yeah.
But it's my understanding that the quote-unquote boating accident incident is the part of another public record, right or wrong. And now it is my understanding, and I think I'm right on this, it's my understanding that other public record does not name him as a defendant, and I'm sorry, I don't remember who your daughter was, I think, but I don't remember that, but doesn't name your daughter as a defendant, okay? So I kind of appreciate that argument because it goes on, there was somewhere in here where it says, except I know I read somewhere in here, except for attorneys, oh, right here, except for the parties' attorneys, financial advisors, bankers, lenders, and as necessary for, so I don't know. In any event, I really appreciate your argument. Now I have to make a determination.
That's fine, Judge. And then on the second piece, which is the unsealing request. The problem I'm having is it's different than the request that may come from a media company.
Do you know your associate made an argument the other day that I hadn't considered? You should tell him a good argument.
Yeah.
You really should. I hadn't thought of this.
Yeah.
I made comments with regards to what I believe ultimately is going to be some court's determination as to the constitutionality or lack thereof of that statute. But the argument that he made, I thought about this in the last 2 days. Correct me, you tell me if I understand the argument right. We don't have to get to that issue with regards to the statute, because what we have here is an agreement between two people to adopt, right?
That's right.
Okay, so we're not dealing with a constitutionality argument on the statute. We are dealing with enforcement of an agreement between the two parties. And I'm gonna be honest with you, I hadn't looked at it that way before, and that does, so you kind of see where I'm going on that, okay? I appreciate the position, Counsel.
Yes, Your Honor.
So tell him I think he did a really good job.
I will,
When
Your
you
Honor.
didn't appear, you tell him I think he did a really good job.
Your Honor, you're approaching this the correct way. And I do want to make one correction.
Well, great minds think alike again, is that what I'm hearing?
Yes, Your Honor. Ms. in her two lawsuits had named his daughter as defendants. In the federal lawsuit, it was initiated actually under admiralty jurisdiction by the boat company that owned the boat at issue. And that was why the pleadings began with the boat company and not versus. We saw that in the California state case, though. So I just want to make sure the court is apprised that he was a defendant in those actions. We're here because Mr. posted on Facebook about what Mr. on a fateful summer day on Lake Tahoe, Mr. along with Mr. teenage daughter, were out on a boat. Mr. was in the water behind the boat. Mr. then instructs his teenage daughter to hit the throttle. As a result of that, the propeller ripped into Mrs. body, causing obviously significant damage, which is still going on to today. She is facing inevitable amputation surgery that's scheduled for later this year. In addition to all of that, to add insult to what was a very real injury, after their relationship, Mr. got to a romantic sexual relationship with Mrs. now former best
Judge,
friend.
this isn't relevant.
No, I've read it, it's there, go ahead.
With her best friend, or now former best friend. Those are the subject matters from which were posted on Facebook that are at issue here. It has nothing to do with the divorce. It has nothing to do with the parties financial information, certainly nothing to do with the party's personal information. Because as the court rightly recognized in going back to the MSA, parties agree that these divorce proceedings and any further information regarding the parties and finances and personal information shall remain confidential. That means the confidential information shall not be disclosed. It's not confidential information that he had gotten into another romantic relationship after getting with my client. It is not confidential information that he instructed his daughter to hit the throttle of a boat while she was right there at the propeller, and the damages that were caused thereafter. That isn't confidential. Obviously, if there's motion practice in terms of proceedings, there's hearings, all those things, the contents of those within the context of divorce, that would be confidential, because at the time, they were covered by the pre-Falcone sealing. But as it pertains to what she was posting about, when she gives a hyperlink, this is the federal case dealing with the boating incident, and it was settled in the divorce, she's talking about the federal case. She's not getting into divorce proceedings. None of those matters. She should say, here's the motion that was filed before Judge Gaudet. No. And when she posts about the relationship between Mr. and her former best friend, that's certainly not covered by any divorce proceedings, certainly not financial information, and it's certainly not confidential personal information, because this isn't a secret affair. He posts pictures with her all the time. This isn't so when we look at this, Your Honor, it is absolutely not a violation of the MSA. And the idea that they would be able to engraft on a restriction for her ability to speak about the boating incident, which is the subject of not one but two publicly available lawsuits, that is the events thereof, which, by the way, we know happened, not just because we trust my client, but because, unfortunately, Your Honor, there was a 55-minute recording of the event. So the facts of what happened aren't in question either. You were right, Your Honor, to observe the order of events here. On May 28, earlier this year, consistent with EDCR 5501, Mr. Ford reached out to my client, alerted her to various Facebook posts, all of which were included, all of the exhibits or citations of the alleged violations of the MSA were included in that. There were other communications as well included in that letter, as the court saw in our exhibits. In response, 9 days later, my client says, I don't agree that it's a violation of the MSA, but I've taken them down anyway. 2 months later, no follow-up, EDCR 5501, just a motion out of the blue. And what was that motion based on? 4 Facebook posts, three Facebook posts plus a text message that all predated the motion and predated those EDCR 5501 communications. There's a reason, Your Honor, that there's not a single date attributed to any of the communications at issue in the moving papers or even on reply. There isn't a single date they give you about that because they know these things happen. There was the EDCR 5501 communication. The posts were taken down, and yet 2 months later, a motion was filed anyway. That is not how this court demands its litigants proceed. There is too much acrimony in these types of cases to not try and resolve the matters in advance, which is precisely why my client said, I don't agree, but I'll take them down. And they, in fact, they weren't up for very long to begin with. And the idea that there's been communications or other posts towards business associates or whatnot, there's no evidence to support any of that, other than his statement under penalty of perjury. Right? We have no communications, we have no emails, we don't have any of that. Okay? And what we see in the reply, the one exhibit they post in reply, is again a pre-motion communication that she made to someone else that has to do with Karen Smith, not a party to this case. The idea that they are seeking to hold her in contempt for violating the MSA, she certainly didn't violate, on things that she has already taken down, and then tell the court she's just trying out here, she's trying to disseminate information that is protected by a confidentiality provision that really only covers financial information, confidential personal information in these proceedings. The court knows that Ms. should not be held in contempt. She didn't disclose any of the specifics of financial obligations. She didn't disclose the parties' property that would be divided upon the divorce. None of the heart of the resolution was disclosed to anyone. So when the fear is she's telling business associates that alimony is X amount per month, and he's struggling to compete in a competitive industry, there are no allegations that she did any of that. Certainly no support for it. It is a far cry to say this is what's happened to me on Lake Tahoe. This is a federal lawsuit, and it got settled, from actually giving the details of the MSA. That would be certainly a violation of the MSA. She says, I'm getting paid X as a result. But that is not what happened here. And as a result, as a result of alimony, Your Honor, obviously, that she has received money is not confidential, but the nature of the agreement would be. But when the court has this, and it needs to go about enforcing its court orders, which include the power to throw someone in jail, it is a serious matter. And when the response is, we need an evidentiary hearing to figure out what they meant, that tells you that there was no business then bringing the motion in the first instance, because none of what was disclosed, or none of what the statements were disclosures at all. They weren't confidential. It's public information. And she's entitled to repeat that public information. As someone who will be an amputee and who's been devastated by this, she will never forget what happened. And unfortunately, it'll be a part of who she is going forward. And the idea that she can't speak about it when there were so many other restrictions in the MSA, right? We see this is what someone owes, this is what you're giving up in return. Very specific about those things. The idea that they wouldn't be specific enough to say, you can't talk about the voting incident, right? You can't talk about my new girlfriend. We know that these things weren't violations. We believe the court should deny the motion for the order to show cause, and there should be no further proceedings on the matter. As it pertains to the unsealing, Your Honor.
I was going to ask, do you want to comment on that?
Yes, and I appreciate the court's interest in the argument that because there was an agreement to keep things confidential, that you cannot seek to unseal them, okay? And the reason I would, in any other instance, I would say, Your Honor, you're probably right, except when it involves the public's right of access to the courts. And I refer the court to the Kamakana decision, the Ninth Circuit decision, which we cited at length, as well as 4 other decisions, the trial courts here in Nevada and in California, and in which every single one of them, the court recognizes that there's an agreement to keep the existence or the terms of a settlement agreement secret. And in the face of that agreement, the decision is that we will not rely upon an agreement to keep or seal the terms of any prior agreement from the public on PACER or other public filing system.
Okay, so let's suppose I agree, let's suppose I don't agree. I think the more relevant question in my mind is a fact-based question.
Yes.
Okay. We know that the terms of the agreement provide for confidentiality. What is your client gaining by me saying, no, everything's going to be disclosed? That's what I'm interested in the mentality.
Mm-hmm.
Look, I understand, trust me, I do divorce work for a living, okay? I understand the hostilities, the emotions of these cases. I understand why she would get satisfaction out of lashing out. I understand why she would, I understand the feelings and emotions that she would get out of, but ultimately, what is the benefit to your client if I say, I am not going to imply that agreement between the two of them regarding confidentiality?
And the benefit is this, Your Honor. If there is going to be a trial in which she faces the prospect of incarceration, she's entitled to be public.
Okay.
And that's,
So I understand that. I understand that argument, but I think you kind of okay. I understand. I understand.
Just briefly, I'll start with the contractual piece. The problem I have is she doesn't have the standard, right? So he wants to talk about all these cases, but they're talking about the public's right to access. Today, what they're asking is, it's an individual, subject to a contract, that wants to get out of a term of the contract. And that would just be like my client coming in. So what are we gonna pick and choose terms? My client's gonna come in and say, I don't wanna do the non-modifiable this or that anymore, I don't wanna have to pay this, I don't wanna have to, he's gonna come in and start picking and choosing terms as well. This court's not gonna undo the contract. That's not what these courts are supposed to do. That's not, we have agreements and finality, and the case law in Nevada talks about finality and divorce, vis-a-vis agreements parties reach. And the fact that the court should uphold those agreements at all arenas, custody, financials, and otherwise. Again, also think about what that means for Nevada law if we start taking these items from parties. I'm not talking about media, I'm not talking about the public. Items from parties where they contract agreements. Think about the business here, MGM, the casino business. How many non-disclosure agreements do they have? Think about prenups and postnups. How many people want those confidential? We have a public policy of encouraging marriage in this state, but people aren't going to get married if we start throwing out contracts and confidentiality clauses and pieces of contracts that they sign off on in the future because all of a sudden they're subject to a breach or a potential action where we're going to be litigating a breach, right? So I think the contract principle stands firm even in the face of the case law cited because the case law really looks at it from a public perspective and the public being the one with the standing, not the individual to the contract. So I think that doesn't have to hold water when you're making a decision here. I think you have to be bound by the contract. The problem I have with what counsel said relative to the violation and the fact that, and the reason I went there, and I was kind of waiting to see what counsel would say about it, about the term and about this idea that we need to understand what the divorce proceedings meant to the parties. The problem I have is her message that says, I know this is inappropriate, I won't text. Again, I promise. She knows she's sending messages in violation of the spirit of the agreement. She knows she's sending violative messages, right?
So you read the word inappropriate to infer knowledge or intent in violating the terms of the agreement.
I do in the context, right? I mean, she's saying in response to these posts, I know they're inappropriate, right? And so to me, I look at that and say,
That was the text message.
if I could finish, I know they're inappropriate, and then I look at the fact that she's looking at the divorce proceedings, and I agree, there is an element of the boating accident that is public. I don't disagree with that. But ultimately, it is an integral term to the contract that they enter into. And the reality of the situation is the financial aspect that comes with the disclosure of this agreement, because it's more than just, I was in a boating accident. That's what they want to make it about. And they want to tell you how bad and sad it was, and that may all be true, right? But at the end of the day, it has to do with there was a resolution of that boating accident in a divorce proceeding. And so the same way that the public isn't naive to the fact that she had a boating accident, or they're privy to that, they're not necessarily naive to the fact, and particularly we have a camera in here today, to the fact that these parties were divorced, right? So at a certain point they were divorced, and they resolved certain claims. And she's bringing those claims and making those public, right? And then it calls into question additional inquiry, it calls into question, what happened to that?
See, that's the problem I have. I've heard enough. I'm ready. I appreciate the arguments. Very, very interesting issues.
Yeah.
Okay. The reality of the situation is, this is a civil contempt proceeding. Okay. In a civil contempt proceeding, it is the obligation of the person alleging the contempt to prove by clear and convincing evidence that there has been a violation of the order. The person opposing the contempt only needs to establish by a preponderance of the evidence that they didn't do it, okay? And I can give you case law. Case law is pretty clear on that. I'll refer to Battaglia. It's a federal court case out of the Ninth Circuit, 653 Federal 2nd, 419, specifically at page 422. I mean, you can look at NRS 22. It's pretty clear. And what I'm doing at this hearing is, I am going to say that taking everything that you alleged as true, I don't find that you are able to establish, specifically not by clear and convincing evidence, that she violated the terms of the decree which incorporates the marital settlement agreement. As I said earlier in the proceedings, earlier during this hearing, the MSA is pretty particular, pretty specific, okay? Confidential, not to be disclosed, divorce proceedings, finances, and personal information. Not to be disclosed, financial documents, pleadings, correspondence, and documents related to the divorce. I empathize with your position. You now, I think you now have a new wife, right? Am I right or am I wrong? No, well, you have this significant other. And there's probably a lot of pressure being placed upon you by her actions. I don't know what you're trying to gain. I really don't. I asked your attorney. I appreciate your answer. You gave me the right answer, okay? What she's trying to gain is if we have to deal with an order to show cause evidentiary hearing, okay?
And I'm happy to withdraw based on the court's order, I'm happy to withdraw the.
Yeah. I was
unsealed.
gonna rule on that too. But I make specific findings that there's no need to hold an evidentiary hearing because based upon that which was provided to me in the pleadings, I don't find that, in this case, the defendant, ex-husband, could meet his burden that's required by statute in case law, even if I held the evidentiary hearing, okay? I do want to issue some orders on the part of the counter motion asking me to. I agree with Mr. Ford's argument. I think the agreement between the parties is relevant in this particular case. This court will not make a determination that the case should be open. I find, and you made a really, really good point, the case law that was cited has to do basically with the public's interest, not an individual's interest. And just understand me, ma'am, if I allowed you to make that argument right now, I'm almost circumventing the agreement that you reached, okay? So I'm gonna deny, so this is what I'm doing. I'm denying the order to show cause, I'm denying the counter motion seeking. Now I gotta tell you, sir, I need you to listen. I have the right to enter an order for attorney's fees, okay? And I do plan on awarding attorney's fees to the mother, I'm sorry, to the ex-wife in this case. I'm being honest with you. I just, particularly with the redaction, I don't know if that's the right word, the exclusion of this, the social media postings within such a short period of time, the period of time that elapsed from then until the filing of the motion, I am going to award attorney's fees. What I'm going to do is I'm going to, hold on, just hear me out. I'm going to direct that counsel for the ex-wife prepare the order from today's hearing. I'm going to direct that there be a paragraph at the end of the order providing for attorney's fees with a $ blank line. I'm going to direct that counsel for the ex-wife prepare a Brunzell deck. I want that filed within 7 days. And in addition to the requirements of Brunzell, I want to see billing statements so that I can determine a fair amount. That's going to be done within 7 days. You're going to be given a period of time of 7 days thereafter to review the Brunzell deck and make comments, okay? And then I'm going to issue a number in the order denying the OSC and denying the request to declare the statute unconstitutional.
Judge, I have a question
Yes, sir.
just on that procedure and policy. So really, you're taking issue with the fact that the posts were removed after the 5501 letter?
On the issue of
Well,
attorney's
because
fees?
I'm looking at the fact that
Okay,
they
well-
prevailed on the OSC, but we prevailed on the contract.
Yeah, but the contract claim wouldn't have been brought if it hadn't been for the OSC.
Judge, they didn't have to bring it though.
This board, we can agree to disagree. There's absolutely nothing wrong with that,
Yeah.
okay? And you are fully aware of what his alternatives are if he disagrees with me. You're more than competent and capable to be able to take care of that. I believe if you look at Roe versus Roe, okay, a case that I think was decided in July of last year,
Yeah.
a case which specifies situations under which attorney's fees get in domestic cases can be ordered. I think that this case fits squarely into Roe versus Roe. I've made my statements. I don't think it was an appropriate motion to file under these circumstances. I think there was probably outside pressure, but I don't know to file the motion. With that being said, where I deem that something is inappropriate and it was done, and what it did was it actually, the specific words in Roe, duplicate or create unnecessary filing, I have the right to award attorney's fees, and that is going to be the basis of the attorney's fees award.
Is the court going to consider the subsequent violation, the continued acts after the fact with private messages then in that? In that decision? Because, I mean, the reality is the only reason she stopped posting is because we're here today. It's finally stopped, but the only reason we're here, she got counsel, and then it stopped.
Well,
And the other thing I have a problem with is the damage that was done by the initial post. And I understand you're not saying it was in contempt, but the reality is his basis to bring it wasn't frivolous. When he looks at those posts, he believed, rightfully so, and she believed by acknowledgement in text, that it was inappropriate, Judge. So that,
you're using the word inappropriate. right?
Okay,
You're
but
trying to-
not him though, but not him.
No, I'm talking to her. You're using
Yeah,
the word
but that's for her, but for
inappropriate.
him, he believed that the divorce proceedings, that term, and because of the broad case law that encompasses what are divorce proceedings, gave him a basis to bring the action. The fact that the court disagrees, I can appreciate that. You're up there, you're the arbiter of what that means today as we sit here. But to say then, at the heightened standard that Roe provides, that now that was an inappropriate motion, when really it came down to your interpretation of divorce proceedings versus what we interpret it to be. Because if you would take my
I
interpretation,
guess
we
what
would
I'm
have.
saying is my interpretation is an objective interpretation.
I agree with that. You have, and that's your job, right? But at the end of the day, to say that he brought a frivolous filing when his interpretation and he looked at it and his counsel looks at it and we look at the case law that's present and says this is a very broad category of things, to then say you brought a frivolous motion, which Roe would require or something to that effect, right? I'm paraphrasing, but at the end.
I was too. I was
Yeah,
paraphrasing.
yeah, and so I look at that and go, that's where I have a problem with the fees, and again, I won't rehash the contract claim, that's for argument and a thing, but here, I don't think it is frivolous, I don't think it means Roe. I can put that in my briefing, Your Honor, and obviously I know you'll take it into consideration.
I really don't believe that there is a substantial basis. I'm sorry, we can agree to disagree, it's okay. Counsel, you're gonna prepare the order, you're gonna
Yes, Judge.
prepare your Brunzell deck, you're gonna provide that to Mr. Ford within 7 days. You'll be given a period of 7 days to respond.
Yes,
Once
Judge.
the response is there, I will evaluate it with the proposed order, and I will make a determination of specifics with regards to attorney's fees. I appreciate both of your time. It was a very interesting issue or issues for me to consider, and I wish the parties the absolute best of luck in the future endeavor.
Thank you, Judge.
We're off the record.